Welcome back to State and Local Government Politics, Module 5, State Constitutions. In Part 2, we'll discuss the content of state constitutions. In broad terms, state constitutions and governmental structures greatly resemble the U.S. Constitution and the national governmental structure because those pre-existing features of government were used as a guide by the framers of the U.S. Constitution. State constitutions differ substantially from state to state, but they are similar in that they are not permitted to contradict the Supremacy Clause of the U.S. Constitution. The Supremacy Clause is the clause established in the Constitution, federal statutes, and U.S. treaties as the supreme law of the land, mandating that judges uphold them, even if state laws or constitutions conflict. In the case of civil liberties, for example, the several states may exceed, but may not set lower standards for the protection of those rights of citizens set by the U.S. Supreme Court in its interpretation of the Bill of Rights of the U.S. Constitution. Civil liberties are individual rights protected by law from unjust governmental or other interference. The limits as to what states can and cannot do with respect to the Supremacy Clause are rather clear. The U.S. Constitution sets specific limits on state powers in Article 1, Section 10. That section restricts states from printing their own money, entering into international treaties, imposing duties on international trade, and engaging in various other official activities reserved for federal government actions. Article 4, Section 1 through 4 specify other provisions pertaining to the states, including extradition of individuals accused of a crime in another state, the requirement for a republican form of government, and the process by which new states can be admitted to the Union. The 10th Amendment specifies that any powers not specifically granted to the federal government in the U.S. Constitution are reserved to the states and the people. This is known as the Reserved Powers Clause. There have been 145 constitutions in the 50 states since 1776, with the average constitution remaining in effect for approximately 70 years. On average, American state constitutions are almost 4 times longer than the 7,400-word U.S. Constitution. Most state constitutions contain around 26,000 words. Currently, the shortest state constitution is found in New Hampshire, a document featuring only 9,200 words. In stark contrast, the longest state constitution contains 340,136 words, and it is found in Alabama. Some include detailed provisions such as hail insurance in South Dakota, citizen access to physician-assisted suicide in Oregon, the width of ski runs in New York, and the active promotion of the catfish farming industry in Alabama. Many observers argue that the longer constitutions featuring many specific mandates make constitutions overly cumbersome and time-bound, and consequently less likely to last over time. They believe that more streamlined constitutions focusing mostly on institutional issues, for example governmental structures and functions, with fewer specific mandates make them more durable and adaptable over time. While the length of state constitutions varies widely, there are common themes found in their provisions, including the establishment of government institutions, the specification of powers of these institutions, the procedures to be followed by public institutions in carrying out their work, and the principles of governance to be observed. The U.S. Constitution allows a wide variety of institutions if they represent a republican form of government. Republican government. Within this system of government, there is separation of powers divided up by executive, legislative, and judicial powers. Additionally, government responsibilities can be centralized at one level of government, or they may be decentralized among multiple layers. All 50 states allow for general-purpose municipal forms of government, and all states have school and special purpose, for example, sewer, mosquito control, rural fire, soil conservation districts. General-purpose government, responsible for a wide range of public services, and include counties, parishes, and municipalities, cities, towns, villages, and townships. These can be contrasted with special purpose governments or special districts, such as school districts, water districts, and transit districts. 20 states also allow for township governments, which historically have been rural subdivisions of counties. Today, however, many metropolitan area suburbs with growing populations have spread into these previously rural locations. Other governmental institutions typically seen in state constitutions include the establishment of state offices and officials, including executive agencies and departments, such as education, transportation, agriculture, fish and game, natural resources and the environment, the Attorney General's Office, Secretary of State, Treasury, Revenue, Welfare or Social Services, Health, Civil Service, various advisory boards, commissions, and governing boards for public colleges and universities. Typically, state constitutions also establish institutions such as state prisons, state mental health hospitals, state libraries, and state parks, and states provide for local school districts and other form of local government-oriented entities to deal with such infrastructure matters as public utilities, irrigation, county roads and bridges, park and recreation facilities, local libraries, health clinics, and hospitals. The powers residing in each institution in the state in general are also included in state constitutions, such as the legislative power for both upper and lower chambers, executive powers held by the governor and other executive offices, such as secretaries of state and attorneys general, judicial powers held by state supreme courts, state appellate courts, and lower courts, powers of taxation and expenditure, powers of local governments, regulatory powers over various areas, including commerce, transportation, environment, business and corporations, criminal justice, powers to claim land or property for public use, and many more. Most state constitutions provide for a plural executive branch with separate elections for such offices as Secretary of State, State Treasurer, Attorney General, State Auditor, and Lieutenant Governor. A typical U.S. state governmental structure outlined in a state constitution looks very much like that of one of our oldest state constitutions, namely that of Massachusetts. Please stop the video at this time to examine the structure of the Commonwealth of Massachusetts. If you're listening via podcast, examine this chart in the textbook when it is safe to do so. State constitutions also outline the processes and procedures of government as well. These can include, but are not limited to, how laws are made, including executive veto and the override process, qualification for election and office holding, terms of office, ballot rules, voter registration and election process rules, size of public institutions, rules for the maintenance of official records, impeachment processes, when and where elections will be held and who is eligible to vote, processes for the initiative, referendum, and referral, and many other procedures not listed here. 44 U.S. states allow governors to veto individual items in appropriation bills, line item veto, and all but 15 states mandate adoption into law of balanced budgets. That is, expenditures provided for must match anticipated revenue for the period in question through their state constitutions. Most state constitutions feature term limits for governors, 38 states, and 16 states have set term limits for state legislators in their constitutions as well. Finally, state constitutions also provide the guiding principles of governance. These principles often follow the U.S. Constitution and typically include many items found in the Bill of Rights, including freedom of speech, freedom of religion, government accountability, the sovereignty of the people, the purpose of democratic government being the protection of life, liberty, happiness, and property. 46 states have provisions similar to the U.S. Constitution's Second Amendment concerning the right to bear arms. California, Iowa, Minnesota, and New Jersey are silent on the subject. Only 10 states guarantee the right to privacy in various specific areas, including financial and medical records, but in other states, these rights have been established by state Supreme Court decisions. While these fundamental rights are found in the U.S. Constitution and provide citizens with a minimal floor of government protection for the individual, the enumerated rights in state constitutions can represent another layer of protection of individual rights. Some controversial areas concerning guiding principles found in some state constitutions include attempts to ban or limit abortion rights and feature provisions making English the official language of the state in question. Many states have changed their constitutions to require parental notification for abortion, and in some states, Colorado, Georgia, and Mississippi, ban abortion even though a complete ban is now unconstitutional given the Supreme Court's Roe v. Wade decision. In May 2021, the U.S. Supreme Court agreed to hear a Mississippi case banning abortion after 15 weeks, known as Dobbs v. Jackson Women's Health Organization. Oral arguments were held on December 1st, 2021, and a decision is expected later this year. In Part 3, we'll discuss changing constitutions.